Mr. Whedon, you may proceed.
Thank you, Your Honor. Good afternoon. As the judge indicated earlier, what the state of Virginia said is not evidence. The evidence came from the witness. And so it's up to you to always think back about what you heard, what you saw in this case, and analyze that. And be critical in your analytical views of the evidence and think through everything. Don't just accept what the state attorney has to say. Because I think it's clear in this case that the foundation of the state's case is based upon sand, shifting sand. The shifting sand is this Janet Gutierrez. This is, in spite of what they just said, this is a one-witness case. And it's clear. All the testimony that they put out there asserting that this Rosario committed these crimes is based upon her testimony. And we're going to talk about her testimony in a few minutes, but there were other witnesses that testified. I mean, the state led off with the first firefighter who came in and testified that he had entered the home, he checked to make sure everything was safe, he poked holes in the ceilings, he caused quite a bit of damage just to make sure there's no fire spread into the house for his safety, the safety of his fellow firefighters, and the safety for anybody that might be in the home. He says also as part of checking for his safety, immediate concerns for the safety of himself and others, is to be sure there was no ignitables in the home. No chemicals, no gas cans, nothing that would cause a fire to accelerate and endanger himself or others for the fire department. Testified, didn't see any gas cans, he didn't see any chemicals, he didn't see anything that would accelerate a fire in the case in Ms. Ortega's home. Testified he retrieved Ms. Ortega, he found her in a room with kind of light smoke or white smoke, and she was laying on a bed, halfway on the bed, with her head on the bed. No one knows exactly how she came to be in that spot. That's where she was discovered. And there was a great deal of blood on the bed, as you heard from the medical examiner, from the crime scene technician person. You heard the firefighter said he noticed some head injuries, but it was his job to get her out of there. And he carried her out of her home and placed her on a stretcher. The state called another firefighter. The second firefighter testified that it was his job to go around the perimeter of the home and to make sure there's ways to get to ventilate the house. And so he walks around the home. He sees all the windows are closed and no windows are open. He sees they're all closed, and so he breaks windows to help ventilate the home. And I asked him, well, did you see any windows that were already broken? Which would you would expect if someone broke into somebody's house. And he testified, no, he didn't see any other broken windows. He had to break windows. He actually had to remove them from the frame of the building. I heard him testify also that, it's common sense that firefighters would be aware of flammable objects or ignitable fluids, begin to be concerned about the acceleration of fires. And you heard him testify. He didn't see any gas cans. He didn't see any accelerants. He didn't see anything that could cause a fire to spread or cause a fire to be ignited. And for the fire department, they also called the fire marshal to testify. And he's an investigative person. You heard him testify. It's his job to go into a scene where there's suspected arson, do an investigation, look around and see where the fire started. You heard his testimony that the fire started in 3 different locations in the home. 2 of the locations were one into the home, one was he characterized as a laundry, in which there were a couple of chairs there, and someone apparently placed some clothing, some cloth on these chairs and set them on fire. And then adjacent to the laundry was what he characterized as a sewing room. And I guess the chairs, the fire was in the sewing room. In the laundry room, there were some towels, the photographs show, were placed over a washing machine and set on fire. And then he testified in the hallway, there was the hallway closet that was set on fire. But he indicated that, his duty is to try to find out first where the fires are located, and then what caused the fires, and to look for inhalable fluids, those kind of things, to make some kind of determination about that. So you heard him testify to those 3 locations. He testified visually. He did not see any combustibles. He didn't see any gasoline cans. He didn't see any chemicals. He didn't see any evidence of anybody using inhalable fluids. But in addition to his visual observations, just using his eyes and that kind of look, he also tried to, he indicated that he took samples from the various locations where the fire started. And the purpose of that was to see if any inhalable fluids were used. And he, from these 3 locations, he took, clothing samples or whatever, towel samples, etc., to have all those things tested to see if there was any fluids, any inhalable things on there. So you heard him testify. He had no observations about anything that was used to accelerate the fire, to ignite the fire, and so it's essentially his opinion this was started by an open flame. Again, no evidence of any gas can. And you heard the state say, well, isn't it possible you might have cut the wrong cloth or missed the cloth or missed the ignitable by an inch or so? And he said, yeah, it's possible. As the state indicated, we were in jury selection, reasonable doubt is not possibilities. So we have to assume that the fire marshal did his job. And there were no ignitables used, no gasoline, no chemicals. And I bring that out because, as you probably already anticipated, that was the testimony of Janet Gutierrez, is that Mr. Rosario had told her to use gas and chemicals to accelerate this fire, to ignite this fire. And so her testimony is not corroborated in that respect of the state of the case. In fact, it's rebutted by the physical evidence. We heard Elena Wilson testify about her mother. Mother was 83 years of age and lived alone. And Ms. Wilson was concerned about her mother, as you would expect, and she checked on her on a daily basis, talked to her on her telephone on a daily basis. Knew her mother from her habits, the daily habits, was one that did not let strangers into her home, kept her doors locked, kept her windows locked, and would not open her door to a stranger. Essentially, that was her initial testimony in this case, which would suggest that this would take a let somebody in her home that she knew or was familiar with. Now, the next witness they called was the crime scene investigator, Ms. Fletcher. So back in September of 2013, she was called out to the scene to exercise her duties, and you heard from her testimony that her duties are to process and document a scene. And process means, gathering, dusting for fingerprints. You heard that she did that throughout the house, doors, etc. For her processing also includes looking for DNA, swabbing for DNA. She did all that. And then her duties also include documenting the scene. You heard her say that she took over 200 photographs, so obviously she did a very good job of that. She noted that there was a great deal of blood on the bed, and that's essentially where the blood was concentrated, was on the bed, and you saw photographs of the heavy blood on the bed. The state attorney suggests that Ms. Ortega was hit and struck while she slept. But as you can see from the photograph, her head is on the bed, or she's not lying in the bed sleeping. That's all. When the state attorney talked about false speculation, that's essentially what they're doing there. There's no evidence that she was in the bed when she was struck. There's no evidence of a struggle in the case. There's evidence that the house was ransacked, the doors were pulled out, etc. But there's no evidence of a struggle because, A witness to testify in those areas, the common sense would tell you, would be an expert witness on crime scene reconstruction. Expert witnesses that talk about blood spatter, if someone is hit or with struggle, what you can expect in terms of blood splatter, blood patterns, those kind of things. We did not hear from an expert on that. So really, you can't really form an opinion about those kind of things because you haven't had anybody to really give you an expert opinion about that, to explain those kind of things to you, how the body reacts to being struck, how blood reacts to those kind of situations. So when the state attorney talks about that, again, essentially they're just asking you to speculate about what may have happened or suggest to you what may have happened, because there's been no really anybody who's qualified to give you a scientific explanation about what may have happened in that bedroom or in that house. All the blood was primarily located on the bed, but the state attorney indicated there's no other blood in the bedroom, but you heard crime scene investigator Fletcher testify that she did swab the dresser, and there was some blood on the dresser, which would suggest there'd been some movement around in the bedroom. But there's no eyewitness to what occurred in the bedroom. Only the state's suggestion to you about what occurred in the bedroom, and only their attempts to rely upon the testimony of Janet Gutierrez as to what happened in the bedroom. Again, this shifting, unreliable witness that they're trying to address the entire case on. We heard the medical examiner testify. I'm going to call her Dr. Z because she had a very long name, began with a Z and fell. I remember that. She testified. She did the autopsy case. She saw Ms. Ortega. She testified, and it was a blow to Ms. Ortega's face, and she's not really clear as to that cause of that injury that you see in the photograph, kind of a mask-like injury across your face. It could have been caused by having on glasses that could have caused the bruising. She testified that she was struck 3 times in the head, and that she had skull fractures in the head. Now, you have to remember, well, in this, the medical examiner testified that because of her age, there would be some degree of brittlest bones, which you have to consider in terms of how much force is used to cross those things. And sadly, because of her age, the brittlest of bones, I would suggest to you that the cross streak would not necessarily be that great. And the reason we know that, one of the things that reflects on that, is you heard the medical examiner testify that Ms. Ortega had injuries that were associated with the attempts of the paramedics to resuscitate her by whatever procedures they used. In any event, you heard her testify that Ms. Ortega had some broken ribs, she had a spine injury, she had liver laceration, which were caused by the paramedics. So I submit to you, you have to consider those things in terms of her injuries and the force that might have been applied, because you heard the medical examiner testify that she was brittle, and the injuries that were caused by the paramedics kind of shows and reflects on that. The medical examiner testified about her injuries, and you did not. She didn't testify about any injuries to her arms or her hands. And going back to the state's main witness, Ms. Gutierrez, as you may recall, she testified that Mr. Rosario told him that she, I think the state admission is in there, that she had to put her arms up behind her fingers. If that was happening, if she was true and correct in her testimony about that, the medical examiner would have notated injuries to her arm, defensive injuries. You would expect that in that kind of scenario that Janet described. And her, the doctor testified on injuries she observed, and she didn't testify on any injuries at all to her arms or hands to suggest any kind of defensive maneuvers on her part, contrary to Janet's claims. You heard her testify that the injuries she received would probably have rendered her unconscious within minutes, and in a kind of lifeless state. And so, common sense would say that a perpetrator would suggest, or would suggest, that would assume that person was deceased at that point. And see, that's really more consistent with what Janet Gutierrez says, that she was woken up by Mr. Rosario, and that Mr. Rosario had said that she was cold, and was suggesting that she had passed at that point, if you're going to suggest it. So you have to consider the doctor's testimony in total, in the assertion and her testimony that a person would have been rendered unconscious, lifeless, within minutes of having been struck the way that she was. You heard the testimony of Detective Thorpe. He's an investigator in the case, he had his job, he has the evidence, and kind of funnel everything in the case to the state. Now, you heard him testify that he didn't really have any leads for a long time. For like 8 or 9 months. And that no one, Janet Gutierrez did not reach out to him. There was no DNA, no fingerprints, nothing to link anybody to this offense, even though you have to assume they did a thorough examination of different scenes. And so he says, when Janet Gutierrez didn't reach out to him, he sent her a subpoena. She came in under a subpoena. And she tells the story about how she wanted, the reason she came in was to protect her sister, who we not heard from. The reason she came in was to get her community.
Sustained. Rephrase, please.
She testified that she was concerned for her sister. And then she testified that she was going to come in and talk only on the condition of immunity for herself.
Yes, please. You may proceed, Mr. Weed.
So when she came in there as a subpoena. It was not a voluntary, good citizen reaching out wanting to do the right thing. It's a human being that she knew she was under threat of prosecution, trying to protect herself from prosecution. I think when you hear her, if you look at her, the totality of her testimony, it's clear that's what she's doing. She's either trying to protect herself or protect somebody else. She would not testify without the promise of the Detective Court recognized that. And then we heard from, this is not the exact order that came. I'm just talking about the witnesses who testified other than Janet. We heard from the last crime scene investigator, actually Church, I believe her name was, and she came on the scene in June of 2014 to go to the Rosario home, process the Rosario home for any potential evidence in the case. And she, along with the text, I guess, dug up the bag that was buried in the backyard, and apparently Janet gave them a drawing that showed exactly where that bag was, where she had buried the bag. Janet had said that Mr. Rosario rode a bicycle to and from the scene of the arson and homicide. And so...
That's not nice.
I can rephrase that, Judge.
Yes, please. Thanks.
I think she said that he rode a bicycle. That was main means of transportation. And crime scene investigator Church swabbed both of the bicycles there. And common sense would tell you that she swabbed those bicycles was because the perpetrator rode this bicycle to and from the crime scene, in which there had been bleeding, that perhaps there would be blood on those bicycles. So common sense says that's why she swabbed those bicycles, to see, I guess, two things: if Mr. Rosario's DNA was on there, and to see if there might be any blood from Mr. Ortega's. And certainly common sense tells you that if there had been any blood or DNA relative to this case, you would have heard about it. They would have brought that in for the evidence case. She testified that, we heard from the school that she had mopped this floor, this bloody floor. And you heard her testify that she got this mop from the kitchen closet where the bucket was. And mopped this floor and then put the mop back in the closet. That was her testimony. And you heard crime scene investigator Ashley Church testify that at the scene, she took the mop out of the kitchen closet. She tested that mop. Well, I'm not sure she said that or not, but she took into physical custody the mop from the kitchen, and then she found a mop outside as well. And you have to assume that they're doing their job. She would have tested that mop from the kitchen, I guess done the preliminary chemical, whatever they do to it on there, and determine if there's any evidence of blood, and sent that off to the FDA on the lab. And that mop was in the kitchen, in the closet, wherein Janet said the mop wasn't she used, apparently never sent to the crime lab. Instead, they sent the mop from outside. And the state showed me this picture of a mop several times, and you have to recognize that's the mop outside. It wasn't the mop in the kitchen. And they want to suggest to you that there's some kind of corroboration happening in that scenario to corroborate her testimony that she mopped up this floor. But again, that's the false invitation because it's not the right mop. The mop that's outside, they said, well, we couldn't do, there's no blood visible in the naked eye. You heard the witness testify about that. And really some kind of chemical test that they did to show that the blood on there, some apparently very, very minute, invisible blood that they found. But you heard the lab expert, the DNA expert from the Florida Department of Law Enforcement testify that, yeah, it wasn't visible naked eye, it's all by chemical process that they discovered that. And you heard him testify that there's no way to know how long this blood was on there. This blood was not visible naked eye. And he said, yeah, it could have actually gotten on there in the factory. He admitted that. So that's no corroboration. That's an illusion that's thrown out there to try to corroborate Janet's testimony, and it totally failed. Now you heard her testify that she got rid of all the evidence. She put it in the bag, and then later on she buried it, and she got rid of the evidence. But the crime scene investigator, Ashley Church, these photographs are all in evidence, and you have a chance to take them back, you have a chance to look at them. But if you recall, when Ashley Church testified, she showed you a photograph of a drawer in that trailer. And in that drawer was a locket or a pendant that Ms. Wilson testified was actually one that she got when she was in high school that her mother kept. And that was in a drawer. And in that drawer were two other rings and other items that you would normally associate with women, hair scrunchies or bands that tie hair up. And so clearly that drawer was a drawer that was used by a female. The drawer that the female that was living in there at that time was Janet Goodrich. So apparently she kept the jewelry. Now, then we turn to, again, as I said, evaluate the testimony of Janet Goodrich. And the court, you look at page 14 of your jury instructions. There's a list there of 9 factors. They're not all inclusive, but there's 9 factors there that the rules say you should consider when you weigh the credibility of a witness. Okay, number 1 is whether the witness had the opportunity to see and know about the things in which they testified. Well, Janet Goodrich said she wasn't at the scene. She was not present, so her testimony just really claims about what she heard Mr. Rosario say, and then just her assertion that's what happened. And number 2 is the witness appeared to have an accurate memory. And so that she, because of changes in her stories, either she was intentionally changing her stories or she was having a memory problem. In the event that weighs against her as well. The witness appeared honest and straightforward in answering the questions. That's debatable. I would submit to you her demeanor on the stand would suggest that her answers were all very stilted, very kind of repetitive, and would suggest a good deal of practice of her part. And did the witness have an interest in how the case should be decided? Well, that really kind of goes to her demands for immunity. It's clear, common sense tells you she has an interest in how this case is decided. And number 5 is that the witness testimony agreed with other testimonies, other evidence in the case. Well, we'll go over all that again some more, but I'll demonstrate to you how her testimony was actually inconsistent. She conflicted with herself, and then also her testimony conflicted with the evidence, the physical evidence that she'll see in the case. So that weighs against her as well. Number 6 is, did the witness receive any preferred treatment or other benefits? And certainly she received preferred treatment because she's not being prosecuted. Even though she's essentially admitted to committed a very serious crime. And then has there been any pressure or threat used against the witness that affected the truth of her testimony? And when she was testifying, you heard the state say to her, you can't get in trouble unless you lie. Well, the threat behind that is essentially, first of all, no one knows whether her testimony is true or not. The state wasn't there. I wasn't there. None of y'all were there. So the only person that would know it was a lie or not would be Janet Gutierrez. And so essentially, when the state makes that kind of statement, the only way you get in trouble is if you lie. They're essentially saying your version about what happened better fit with our version. And then number 8 is whether they made inconsistent statements and suggest to you that was pretty clear from her testimony. We'll demonstrate that further as we go along. And then number 9 is, has the witness been convicted of felony? You heard her testify, yes, I'm a convicted felon. Why is that important? Because it suggests, people that are convicted felons don't have, or they have a minimal respect for the law. That lack of respect for the law when there are felony convictions makes you question the veracity. Not only is she a convicted felon, she's currently on 4 years of probation. You heard her testify, yeah, I don't want to be found in violation of probation. She's worried about that. And why would she be worried about violating probation? Because she has a 2-year jail sentence hanging over her head. Now, to suggest to you all those 9 factors all weigh against the credibility of Janet Gutierrez. You turn to page 15, and we're going further with the jury instructions. You go to the 3rd full paragraph. That paragraph talks about what they call accomplice testimony, and whether or not, if a person says they assisted in the commission of a crime, and then promised immunity, you have to look at that. You have to consider whether the person has a reason to make false statements to strike a good bargain, and what better bargain could there be other than not being prosecuted? That's like the ultimate bargain. And that's what she got in this case. You go on to read the next sentence, says, this is particularly true when there's no other evidence tending to agree with what the witness says about the matter. And there are no other witnesses who testified that corroborated her story about what she claims of her Mr. Rosario said. They try to bring in some things like the mob, hotel room run by Lucas Garcia, things like that to suggest corroboration. That's just all circumstantial, speculative. No direct corroboration for anything that she had to say. Yeah, so who is Janet Gutierrez? She's a young woman. By her own admission, she's been fighting drug addiction for years. Common sense again will tell you that people that have drug addictions have problems with reality. You also live in denial.
Sustained. Rephrase, please.
You can draw whichever you want out of that. You heard her testify, she's a drug addict. We've talked about all the different things that she's related to the weight of the evidence. And so, she comes in under subpoena. She's placed under oath. Apparently all of her statements that she gave were under oath. She was asked to testify or offer testimony about what had happened and to tell what she observed occurred. And I submit to you, her testimony conflicted within itself. She was inconsistent with her own observations and testimony. And her testimony, as I indicated before, was inconsistent and conflicted with the actual physical evidence in this case. Now, she got on the stand, direct examination, the state attorney asked her, well, tell your story about what you heard, and that Mr. Rosario had said, I don't know what I'm doing, but I have to go back and kill this woman because she saw my face. But you heard her testify that, we're confronted with her prior sworn testimony that was given back in June of 2014, given to Detective Thorpe, given to the other detective who was there, given to a representative of the state attorney's office. Her testimony then was that Mr. Rosario woke her up, said she's cold. And of course, the implication is that he's referring to Ms. Ortega. But she's cold and I have to go back to set fire to destroy evidence. Now, and I said to her, well, if he said that to you, wouldn't the implication be that when he woke you up, he already thought she was deceased? That's your testimony? And she goes, oh no. I wouldn't interpret it that way. Again, you don't leave your common sense outside the jury room. You take it back there with you. When someone says that a person is cold under these circumstances, or their body is cold, then the natural implication of those words, that when someone speaks them, is that they believe that person is deceased at that point. So if you go with that version of Janet's testimony that she gave under oath previously, if you accept what she's saying, then in that scenario under oath, then the implication would be that the perpetrators went back to the house just to destroy evidence, to get rid of fingerprints or whatever, not to kill anybody. So her own statements and her oath can flip with one another, which means that, how can you can't rely on either one then? That's the natural implication of that. And for her to say that that word didn't mean deceased to her, she kind of contradicts herself. She says then later on that, oh, he went back there and she was cold and no pulse. So she's not using the word cold to mean deceased, and that's certainly a contradiction in that other statement that she made. And the state indicated, well, we know that the person did a good job of destroying the evidence because they didn't find any fingerprints or any DNA. Well, you saw where the fire was set in the sewing room, the laundry room. It didn't really destroy anything. In the bedroom, there's no fire in the bedroom whatsoever. So there's no indication by it was excessive destroying the evidence of the case. She contradicts herself again when she said on the stand that Mr. Rosario had specks of blood, spots of blood. When she gave the statement to Detective Thorpe in the state attorney's office back in June 2015, she said that he was covered with blood. So she's conflicting with herself. She had said when she testified here in court that, well, she doesn't remember if there's any blood or not in the trailer. And she testified to Detective Thorpe, to the state attorney back in June 2014 under oath. There was a blood show. The blood show may have been words used by Detective Thorpe based on the interview he was having with her, but you heard, when we talked about that, he said, so it was a blood show, and she said yes. Well, the big difference between a blood show, well, she said she didn't remember any blood. But that just goes to show she's a stranger to the truth. She said that she mopped the floor from the entrance all the way back to the bedroom, all down this hallway, to mop up the blood. And then now she says, I don't remember if there was any blood there or not, I just mopped the floor just in case there was blood. But again, there's really no evidence to indicate she ever mopped it. With the mop, she said she used it in the kitchen closet, and they took that mop into evidence, and there's no evidence there was any blood on that mop. There's the crime scene technician that went into the house and the trailer, processed that trailer. Didn't develop any blood in there either. And like I say, her testimony is in conflict with the physical evidence, and that's an example of that. Now in regards to the physical evidence, again, her testimony about physical evidence, she said that Mr. Rosario had 3 suitcases, various sizes. One suitcase, she said, was this big. And so her version about what happened just doesn't make any sense. That someone could go down there, ostensibly on a bicycle, and bring back 3 suitcases. So that testimony suggests either she was there, covering the suitcases back, or she's covering up for somebody else. Because again, common sense tells you one individual coming back ostensibly on a bicycle, or even walking, can't be carrying 3 suitcases by themselves. Again, like we talked about before, the testimony being conflict with the evidence, they're testifying there was a gas can was used, the chemicals were used, and there's no physical evidence whatsoever to corroborate that assertion. The testimony that she got in through a window. Again, there's no evidence to corroborate that. The firefighter said the windows were all closed. No indication it was damaged. Ms. Wilson, her daughter, testified her mother was very good about keeping the house closed down. There's testimony that Mr. Rosario supposedly said that she had her arms up and said, please, you don't have to do this, and hold her arms up to defend herself. There'd be no injuries on her arms, no defensive injuries. Shows that there's no physical evidence to corroborate what she's saying. The state has come to you with these charges of premeditated first-degree murder. And the premeditation, they're based solely upon the testimony of Janet. And what she claimed she heard said. And then the speculation about how much time it would have taken to hit somebody, time for reflection, those kind of things. And the felony murder by burglary taking place, which require entry without consent of somebody, those different things. Again, based solely upon the testimony of Janet. The only thing that would really stand aside and apart from her testimony would be on that state's theory about second-degree murder, or charge of second-degree murder, which doesn't require an intent to kill. That instruction that they read to you was that second-degree murder involves an act that's eminently dangerous with a depraved mind regardless of human life. I suppose that charge stands aside, perpetrator could be convicted without the testimony of Janet. In any event, the state indicated this is my only chance to talk to y'all. When I sit down, Ms. Bear will get up here and speak and say things in response to what I just said. And I won't have a chance to really talk to you again and to respond to what she may say. But I would just challenge you to be critical thinkers, to listen to what she has to say, and then decide and think, well, is that really important with the testimony we heard? And think, well, what would Mr. Whedon say about that, or what would be a kind of argument to that? Because you got to do that. You all agree when you're part of the jury pool that you would be critical thinkers. You would analyze evidence and go back to deliberate, talk to the other members of the jury, and listen to what they have to say. And if you think your decision is the correct one, stick with it. I just want you all to continue to do that. But, finally, what I want you to do, what I want you to consider, it's often said that reasonable doubt is really proof beyond reasonable doubt is really proof is so convincing that you would be willing to act on it without hesitation in the most important of your own affairs.
Objection.
Your question?
Yes. Ladies and gentlemen, you have the definition of reasonable doubt that I've already read to you. Go ahead, Mr. Weed.
There was one of the things that I wanted to talk about today. you heard Janet Gutierrez say that she was fearful, and that's afraid of this Rosario, and that's why she never treated her. And I assume that, we didn't hear that in her opening, other closing statement from Mr. Williams, but I assume that's going to be said later on when I sit down. But think about that too, okay? Because you heard her testify that she wrote him letters after the incident with she elections, that she wrote him letters telling him she loved him, she wanted children with him, she wanted to marry him. Well, she wasn't fearful of Rosario. It was only, that went on for at least a few months, and then she ended up going back with her children's father. So don't buy into the argument or the assertion that she didn't come forward because she was afraid of this Rosario. She didn't come forward because she was afraid for her own liberty. It's clear from the evidence, it's clear from the fact that she was convicted in. And so again, I just want to challenge you all to go back, continue to think, talk to the other members of the jury, be analytical, see that this case is really resting upon a very solid foundation. And ask you to turn further and not give it.
Thank you, Mr. Whedon. Ladies and gentlemen, do you need a break before I'm getting nods of yes. All right, why don't we take a 15-minute break?
Executive.
All right, anything else we need to discuss? Recess.